Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina's weekly business meeting. Before we proceed, let's take a brief moment of silence. Thank you very much. Um, I will now move to a roll call. Uh, Present here in the hearing room. Okay. All right. If you would please bear with us. It seems as if we're having some technical difficulties. All right. I'm going to ask our productions team if we need to take five. All right. Ladies and gentlemen, please rejoin us in about 10 minutes. Thank you.
We have a slide that says consultants will be back momentarily.
Yep.
There we go. Hey there.
Yeah, after this morning, nothing would surprise me.
Thank you, ladies and gentlemen, for your patience. We're now back on the record, and our technology is working with us. Let's take roll call. Here in the hearing room, we have Commissioner Powers, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioner Irvin, Commissioner Thomas, and Commissioner Caston. And not seeing Commissioner Williams. She is on leave today. Before I turn things over to Attorney Butler, I do want to say thank you to Vice Chair Belzer, who has chaired several meetings and hearings during my absence where I was working virtually. It's always good to have good help, and she definitely made sure things ran the way they should go while I was away. So thank you very much, Vice Chair Belzer. Attorney Butler, if you would please read the agenda.
Yes, sir. Thank you, Mr. Chairman, other members of the commission. The first order of business would be to set the next commission meeting, and staff would propose that that be on February 24th, 2021 at 11 a.m.
All right, the next business meeting will be February 24th at 11 a.m.
Thank you, Mr. Chairman. With that, we'll go to the commission's utilities agenda. Item number 1 on that agenda is docket number 2020-240E. This is a complaint of Bernard McFadden versus Dominion Energy South Carolina Incorporated. Staff is presenting to the commission today for consideration the motion to dismiss filed on behalf of Dominion Energy South Carolina Incorporated.
Is there a motion?
Mr. Chairman, may I be heard?
Commissioner Powers, the floor is yours.
Thank you, Mr. Chairman. January 25th, 2021, Dominion Energy South Carolina Incorporated filed a motion to dismiss the complaint of Mr. Bernard McFadden for failure to provide a filed direct testimony and exhibits. When the matter was set for hearing before the commission, the clerk's office sent a notice of rescheduled hearing in its pre-filed testimony letter per commission order. Mr. McFadden was instructed to file with commission 1 copy of his direct testimony and exhibits for any witness that he intends to present at his hearing before the commission. To date, Mr. McFadden has failed to make a file on direct testimony exhibits. He also did not respond to or comment on the motion to dismiss filed by Dominion, asserting that he has failed to prosecute his complaint. I would move that the commission grant Dominion's motion to dismiss without prejudice. This motion would not prohibit Mr. McFadden from timely refiling his complaint if he intends to pursue his claim. Based upon the record available from the DMS, it is my understanding that Dominion has offered Mr. McFadden the opportunity to have another meter test with him present. While Mr. McFadden was unable to schedule a time to be present for the test, Dominion maintains in its motion that the offer of Mr. McFadden to be present at another meter test remains available, and that Mr. McFadden need only contact Dominion if he desires to have his meter tested in his presence. I would so move.
All right, hearing Commissioner Powers' motion, is there any discussion? Commissioner Powers, I appreciate your motion. I would ask if you would be open to a friendly amendment. My amendment would be that we instruct staff to add an item to the agenda on the 24th of February to further discuss pro se litigants and how they appear before the commission. I was always taught not to think too much of yourself, and the Public Service Commission is a great entity, but we're not the Supreme Court. We want to make sure that we're accessible to any party that wants to appear before us, but we also have to comply with the rules. So if you would not mind, I would ask that a friendly amendment to your motion be added, that we instruct staff to add an agenda item to the meeting scheduled for February 24th to discuss the process of pro se litigants appearing before the commission.
Certainly, Mr. Chairman.
All right.
Mr. Chairman, may I be heard on that amendment?
Commissioner Belzer, Vice Chair Belzer, the floor is yours.
Mr. Chairman and Commissioners, I certainly do not oppose adding an item to an upcoming agenda. I just don't know that that is needed in this motion regarding this complainant. To me, that's a more general matter that encompasses a lot more than this single complaint. I would suggest that it might cloud the motion before the matter before the commission on this agenda. I think that the chairman can certainly request that staff add that without the need of a motion. Can add an agenda item for the next agenda without the need of a motion. But that's just my opinion. By putting it on the next agenda, that would comply with FOIA, the Freedom of Information Act, and public meeting request, that it is an item on the agenda for discussion at the next meeting, but I don't know that that would necessarily take a vote of the commission to do so. That's my comments.
Understood, understood. And I think that's fair. I think we can go in that direction without clouding the motion. Commissioner Powers, I'm withdrawing my friendly amendment. All right. Any more discussion? Hearing none, we'll move to a vote. Vice Chair Belzer,
I vote aye.
Commissioner Caston, we'll come back to Commissioner Caston. Oh, Commissioner Caston? Commissioner Caston, I think you may be muted.
Aye. Can you hear me now?
Yes, sir. We got you loud and clear.
Aye.
Commissioner Irvin?
Aye.
Commissioner Thomas?
Aye.
Commissioner Powers?
Aye.
And Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman and other commissioners, item number 2 on the agenda comes from docket number 2019-326E. Staff is presenting for commission consideration Duke Energy Carolinas LLC and Duke Energy Progress LLC's application for approval of modifications to South Carolina generator interconnection procedures to implement Q reform and also Appendix Duke CS.
Is there a motion?
Mr. Chairman,
Commissioner Thomas?
I move that the commission approve the Duke Energy Carolinas LLC and Duke Energy Progress LLC, collectively the company's application for approval of modifications to the South Carolina generator interconnection procedures to implement Q reform and Appendix Duke CS, i.e. the application. I so move.
Hearing Commissioner Thomas's motion, is there any discussion?
Mr. Chairman, this is Commissioner Irvin. May I be heard?
Yes, you may. The floor is yours.
Thank you, sir. I support the motion by Commissioner Hedden. We've needed Q reform for some time. It's already been accomplished in North Carolina and the Duke territory, and we certainly need it in South Carolina. So this is a step forward, and I commend the utility for working with the stakeholders to resolve the long delays that solar QFs have been encountered with in the past several years in terms of getting connected to the grids. Support the motion. Thank you.
Thank you, Commissioner Irvin. Any more discussion? Hearing none, we'll move to a vote. Vice Chair Belzer,
I vote aye.
Commissioner Caston,
Aye.
Commissioner Thomas,
Aye.
Commissioner Irvin,
Aye.
Commissioner Powers,
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, item 3 on the utilities agenda is docket number 2020-279E. This is a complaint matter. Pacific Companies is a complainant versus Duke Energy Carolinas LLC as a respondent. The staff is presenting for commission consideration Duke Energy Carolina LLC's motion to dismiss.
Is there a motion?
Mr. Chairman,
Commissioner Belzer?
thank you. On January 6, 2021, Duke Energy Carolinas filed its answer and motion to dismiss in this docket. The complainant has not responded to the motion to dismiss. Therefore, based on the pleadings in the docket, I move that the commission grant without prejudice the motion to dismiss filed by Duke Energy Carolinas on the grounds that the complaint is moot and that an interconnection agreement for the interconnection request assigned Q number 2018-01289 has been executed. Further, The complainant did not follow the dispute resolution procedures outlined in South Carolina Code Annotated Section 58-27-460C and the approved South Carolina interconnection procedures. I so move.
Hearing Commissioner Vice Chair Belzer's motion, is there any discussion? Hearing none, we'll move to a vote. Vice Chair Belzer,
I vote aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers, Chairman Williams votes aye. The ayes have it, the motion carries.
Mr. Chairman, other members of the commission, item 4 on the utilities agenda is docket number 2020-275S, which has to do with Condor Environmental Incorporated. Staff is presenting for commission consideration Condor's letter requesting to continue to hold this matter in abeyance.
Is there a motion?
Chair Williams, this is Commissioner Caston. I'd like to make a motion.
Commissioner Caston, the floor is yours.
I move that the commission grant Condor's request to hold matters in this docket in abeyance until March 1st, 2021, including notice deadlines, the return date, the pre-file testimony dates, and the hearing date. The company and ORS will submit a written status report on March 1st, 2021, on their efforts to resolve the issues in the case. I further move that after reviewing the report, the commission shall establish a new procedural schedule. I so move.
Thank you, Commissioner Caston. Hearing Commissioner Caston's motion, is there any discussion?
Mr. Chairman,
Vice Chair Belzer?
I am in support of this motion from the materials provided to us from Mr. Torini, who's one of the attorneys for the applicant or the utility here. My understanding that they are working with the Office of Regulatory Staff to try to reach a settlement or bring resolution to some, if not all, of the issues. I understand from the docket that it was time to publish a notice of the hearing, and part of the reason for this request is to hold in abeyance is to avoid having to spend money to publish the notice when it may end up being a settlement reached or the hearing date being moved as they continue to engage in discussions with ORS. So I think that this is an appropriate use of the request to hold something in abeyance to help the utility not spend money needlessly or that may have to be spent again. So we appreciate the parties letting us know of the situation and making this request. Thank you.
All right. Any more discussion? Hearing none, we'll move to a vote. Vice Chair Belzer?
I vote aye.
Commissioner Caston?
Aye.
Commissioner Irvin?
Aye.
Commissioner Thomas?
Aye.
Commissioner Powers?
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Thank you, Mr. Chairman, other members of the commission. This does complete the commission's utilities agenda for this business meeting. Moving on to the transportation agenda, staff would recommend that items 1 through 5 be taken together, and these are as follows. Item number 1 is docket number 2021-36-T, the application of Chase Fairways LLC for Class C Charter Certificate. Item number 2 is docket number 2021-37-T, application of Kiowa Island Community Association, Inc. for Class C Charter. Item number 3 is docket number 2021-38T, the application of Ingenuity Investments, LLC, DBA Joyride Transportation for a Class C Charter Certificate. Item 4 is docket number 2021-40-T. It's the application of DSS Transportation, LLC for a Class C non-emergency certificate. And item number 5 is docket number 2021-41-T, the application of Care on Wheels, LLC for a Class C non-emergency certificate.
Is there a motion?
Mr. Chairman,
Commissioner Powers.
Thank you, Mr. Chairman. I would move that the new applications of Class C authority in items 1 through 5, as read by Mr. Butler, be granted.
Thank you, Commissioner Powers. Hearing Commissioner Powers' motion, is there any discussion?
Mr. Chairman,
Vice Chair Belzer?
does not item 2 also involve a request for a waiver?
Yeah, Madam Vice Chair, if I might address that, it does indeed, and that request has now appeared separately on the agenda.
Okay, thank you.
Yes, ma'am.
Any more discussion? Hearing none, we'll move to a vote. Vice Chair Belzer?
I vote aye for approval of these applications.
Commissioner Caston?
Aye.
Commissioner Irvin?
Aye.
Commissioner Thomas?
Aye.
Commissioner Powers?
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Thank you, Mr. Chairman. Other members of the commission, item number 6 on the transportation agenda is docket number 2020-188-T. This is the application of Jaga Movers LLC for a Class E household goods certificate.
Is there a motion?
Mr. Chairman,
Commissioner Thomas?
I move that the commission deny the application of Jacob Movers LLC for a Class E household goods certificate of public convenience and necessity. Approval of Jacob Movers application would be inconsistent with the public interest. So moved.
Hearing Commissioner Thomas's motion, is there any discussion?
Mr. Chairman,
Vice Chair Belzer?
I concur with Commissioner Thomas's motion. I am concerned regarding information that was provided in the late filed exhibits. When movers of household goods are approved, they go in and they are in people's homes. They take possession of people's property, and it's incumbent upon us to ensure that those applicants seeking a household goods authority are going to adhere to all rules, regulations, and properly take care of people's property and possessions. So I do agree with the motion, as much as I hate to deny anybody, but I think that in this case it's appropriate. Thank you.
Any other discussion?
Chair Williams, this is Commissioner Caston.
Commissioner Caston?
I too support the motion. It is my understanding that an application or a future request is not prohibited, just not at this time based on existing conditions. Is that correct?
Mr. Chairman?
Vice Chair Belzer?
If I may respond to Commissioner Caston, the statute allows an applicant who has been denied in an application to file, they can't file before 6 months from the order denying the application. So they can file again in 6 months once the order, from the date of the order.
Good. Thank you. And that was my understanding, something like that, because it is, I concur with what you said, Commissioner Belcher, and also recognize that our past does not define our future, and the future can be different. It just sometimes takes a little longer. Thank you, and I support the motion.
Any other discussion?
Mr. Chairman, this is Commissioner Irvin.
Commissioner Urban, the floor is yours.
Thank you, sir. I also support the motion, and I think I could say for all commissioners, we have nothing personally against this individual It's his South Carolina driving record and criminal conviction record that disqualifies him from being a home mover at this time. And what I'm hopeful is that if he does choose to reapply, that he can clean up some of these matters. For example, if they're at fault driving accidents that he was involved in, he can go to Midlands Tech and take a driving safety course for which he can obtain a certificate of completion, which would be a nice thing to see if he does choose to reapply. And if he's also on probation or parole due to prior convictions, it would be nice to hear from his probation agent to determine whether he's made progress toward rehabilitating his record. We understand that people make mistakes, and we should give them an opportunity to try and rehabilitate themselves, and so there are paths forward to do that if the applicant chooses to reapply. But given the number and severity of the offenses documented in the late filed exhibits, we really have no choice under the existing law and regulation but to find that he's unfit at this time. I would also encourage the Office of Regulatory Staff, when they are reviewing a prospective applicant that has a criminal conviction history of fairly recent origin, who may be on probation or parole, to look into it further, because it will be helpful to the Commission to know what the conditions of probation or parole are. For example, some judges have specific provisions that under certain circumstances, a criminal conviction prohibits an individual from driving a motor vehicle. So that would be an important thing for us to know. If we certainly don't want to approve someone who's under a court order not to drive or who's had their license suspended. And finally, I would encourage them to refer these applicants to get a driving school certificate from Tech. I think its course can be taken on a Saturday. I know that I've heard it's not expensive. It's not a costly thing. It's actually a public service to try to improve the driving record, and an individual can actually get some points back off their license upon successful completion. So, having said that, I support the motion to deny this application. Thank you.
Any more discussion? Fellow commissioners, I must say that I've spent a significant amount of time considering whether or not I would approve or deny this applicant's application. I think it's important for me to note several concerns that I have with where we are with this applicant and what this situation represents. It may not be obvious to the uninitiated. Correct me if I'm wrong, the Office of Regulatory Staff represents the public interest of South Carolina in utility regulation. That same office told the Commission that this applicant was fit, willing, and able to operate as a driver, a mover in South Carolina. I'm not mistaken by that, am I? I didn't think so. Also, I'm not aware of any law that prevents an applicant with a criminal history or with convictions or negative items on their driving history from being a mover in South Carolina. And so what we have here is the Commission operating within its discretion to make a determination whether or not this mover, this applicant, should be allowed to operate in the state. And it's within, the law says it's within our discretion my concern with this is that this applicant did everything that they could have done to show that they were qualified to serve as a mover. They hired an attorney, they got the proper insurance, they got equipment. They even had, if I remember correctly, some funding, some money in the bank, got a small business loan. And the only thing that's keeping them from operating is our vote here today. I am conflicted that the Office of Regulatory Staff, who is charged with representing the public interest of South Carolina, found this applicant fit, willing, and able. And yet the commission, based on a review of criminal history, and I'm not sure whether or not ORS reviewed the criminal history or not, is more than likely going to find that he's not fit to operate in the state, and it's against the public interest to give him a license as a mover. And so, what does that mean for this applicant and other applicants like him or her? Are we saying that if you have a criminal history, you need not apply to be a mover? Are we saying that despite ORS's testimony that this applicant is fit, willing, and able, that testimony means nothing, and we believe that the applicant is not? Moving forward, how will we determine other applications in the future who may or may not have a criminal history and ensure consistency? As a former prosecutor and former criminal defense lawyer, I've prosecuted and represented people who have been charged with crimes. They've pleaded guilty, but the matters are not as simple as they may read on a criminal background check. I think Commissioner Thomas's motion is fair in that it's probably looking at the applicant from a perspective of, based on what we see here, we're concerned about you taking possession of people's belongings and going in their house. But here's an interesting question. Do we have any oversight over an applicant once they are approved of the employees that they hire? I think the answer to that question is no. If that's the case, then we really don't know who they're hiring. They could hire people with criminal records, and we'll have the same situation. So it seems that we're creating a precedent that you're good enough if you're a criminal, convicted criminal, to be a worker, but you're not good enough to be an owner. And that seems a bit concerning. Now, I know we only can control what we can control. We can control this based on what we've seen. We can't control once the applicant is approved who they hire. We have no oversight over that. But I think it's worth noting that if an applicant is approved, they can go and hire whoever they see fit. And we have no oversight. And this gentleman said that he had worked as a worker before, moving items, and it gave him a sense of purpose and pride, and he was encouraged to be an owner and to come before the Public Service Commission. And now he's about to find out that all of his experience and all of his effort to overcome his past, at this point, it looks like it was in vain. I'm not necessarily against the motion as much as I want to make sure that we're consistent. And I'm very concerned that ORS found this applicant fit, willing, and able. And I can't remember if they looked at the, I don't know. I can't remember if they looked at the criminal history or not. Maybe they did, maybe they didn't.
The driving record and the criminal history record came in as late filed exhibits. So they would not have seen that prior to that. And it's not required by the regulations that they.
And that's,
That may be something we need to fix.
that may be, that may be. I would be interested, I will say this, I would be interested to know if ORS would still find the applicant fit, willing, and able based on the information that we've received.
Chairman Williams.
Mr. Chairman,
I heard Commissioner Caston first, then Commissioner
All right.
Irvin.
go ahead, Mr. Caston.
First of all, let me say, Chairman Williams, the things you said relative to judging and everything else, I concur with in this sense. You know, dealing with it personally in my personal family, I absolutely understand the difficulties individuals have who, for whatever reason in their past, have led to whether it be driving, criminal convictions, or whatever. I absolutely understand the burden that it places not on just that individual, but the family and those around him. And I also understand without question how they are generally viewed by most people. For example, I have a family member right now, been looking for work for some time, but when that comes up, I mean, he's automatically pegged. And it pains me. I don't like it. Because I know that, okay, that is past. It would be good for someone to give him a chance for the future, but it is what it is. So if anyone understands this, I believe I do. And I struggled with this one particular one. The thing that brought me to where I am, right or wrong, is that, and I understand why the applicant may not have wanted to put this information up front early, because that's exactly what happened with this family member. Is you put it on that application, have you been convicted of a crime or felony or whatever? When you check that box, no matter what anyone tells you, usually those go in file 13, not a callback. So I get it. I don't think it's right and I don't think it's fair, but it is what it is. But I also feel like there is a certain obligation, because I had to look at that fit, willing, and able thing too. And even when I read it, it still didn't tell me, is that fit, willing, is that fit, or is it not fit? It does come down to some level of discernment, judgment, subjective thoughts and viewpoints. But with all this put together, especially coming in kind of late, and the concern is that, some of this was reasonably recent, I don't think the young man should be judged for it either. The only thing that matters is what are you doing now and where you're heading in the future. And we don't need to do things to hold people back to make it harder for them to move forward in the future. So I struggle with that. But that said, I feel comfortable saying maybe a little more time to prove that. But then again, I can sit here and tell you, I don't want to harm the man, and I would have just as well voted, in support of it. So I'm not trying to be wishy-washy about it all. I understand what you're saying, Chairman Williams, and I do think we need to maybe have a better understanding of what fit, willing, and able is, and perhaps have a much better understanding of what are we going to be looking at. I think if you're going to be moving people's stuff, or driving a taxi or whatever it is, probably ought to have an idea about your driving record or your criminal history. just because, not to judge you from it, although people will, especially if they find out. But I'd rather not find out after the fact. So it appears that for the last year, 2 years, you've been on the right path and a good path. Again, that probably muddled things more than helped them, Chairman Williams, but I understand, and this pains me greatly. That's all I have to say.
Commissioner Caston, thank you for your comments. I'm sorry. Commissioner Urban.
Thank you, Mr. Chairman. And I understand, Mr. Chairman, your thinking in the matter. This is not an easy case. And I think all of us would say we don't want to harm this individual. If anything, I'd like to see him clean up his driving record and come back and reapply. But as I recall, and you correct me if I'm wrong, but as I recall, ORS had no opportunity to see the late filed exhibits before rendering their opinion as to whether he was fit, ready, and willing to be a licensed motor carrier of household goods. Now, they didn't have that information. We do. And we have to give it the weight and credibility we think is appropriate. Now, one of the other commissioners called to my attention that the applicant has 3 accidents fairly recently. I believe the last one was in January, where he was found to be at fault on the public highways in our state. Now, we have a duty to the public to be sure that we are not licensing someone to drive a box truck up and down the interstate if they're not exercising good judgment and not familiar with the laws that relate to safe operation of a motor vehicle. And so we have to draw a line and say, and look at the regulation. I'll read it to you because I think it's relevant. South Carolina Regulation 103-133 states as follows, and I quote, "Fit is defined under subsection A as follows. The applicant must demonstrate to the commission that the applicant's safety rating is satisfactory," end quote. Now, in my view, he has not met his burden of proof. And as far as the ORS witness who testified, in my view, he had no knowledge of these prior at-fault driving violations. And so we have the right to give that testimony such weight and credibility as we would any witness. I don't think, and no fault to their own, I know they are overworked and they can't necessarily run updated reports in every case, but in this case, as I recall, the attorney was pretty forthright in saying that there's a record, and I don't recall who asked for it, but somebody said, let's have a late filed exhibit of his driving record and his criminal history. I'm more concerned about his driving record, quite honestly, than I am the criminal history. And I'm all for rehabilitation. And there's nothing that prevents him from coming back under the law and reapplying in 6 months. But if he comes back, I certainly want to hear more about why he had 3 at-fault accidents over a short period of time. He's in jeopardy of losing his license to drive because of the points that he's accumulated. And so I think we're doing the right thing by denying this applicant. We need more information, and he simply hasn't shown us to date that he's ready to safely operate a motor vehicle in our state. Without additional information, I don't think we have any choice in this case. But thank you for hearing me out.
And fellow commissioners, I definitely don't want you to mistake my comments as being simply opposed to the motion. I'm really more so concerned about the process. Um, while I understand that ORS didn't have the information that we requested, it seems to me that if they're going to be a party to these proceedings and present information for our consideration and make sworn testimony that an applicant is fit, willing, and able, they should use the investigatory powers that they have under law, because we don't have those. And I can't say whether or not the applicant's driving record was considered by ORS or not. I use this time for a little anecdote. When I was a prosecutor, there was a gentleman who, on his rap sheet, his SLED report, had what looked like, not even what looked like, were 3 prior convictions for possession with intent to distribute narcotics. And the way the law read at that time, if he had another drug offense, at that level, the charges or the penalty could be much stronger. His lawyer, both at sentencing, requested the judge to give him an opportunity to go pull the records in the county where he was charged, because he didn't believe that, and I said PWID, it wasn't public, it wasn't possession with intent to distribute, it was actually trafficking. He said, "Judge, please give me time to go to the clerk of court in this county and pull the file, because my client is telling me that he was not convicted of trafficking, even though on the SLED report that I had from SLED in my file, it clearly said he was convicted of trafficking." Well, lo and behold, the lawyer pulled the record, and he wasn't convicted of trafficking. And that sort of changed my view of SLED reports at the time. Not that mistakes don't happen, but when they do, sometimes they can be very consequential in someone's life in certain situations. And so this gentleman apparently had 3 accidents in a short period of time based on what we see. But we don't really know all the facts regarding those. And I'm not saying that if we knew all the facts, it would change how any of us feel. But I just think we should give ORS the opportunity to review the information that we reviewed to make a determination whether or not they still believe that the applicant is fit, willing, and able. Is that not a
Chairman,
fair option?
Are you asking, this is Commissioner Caston, are you suggesting to Commissioner Thomas that be a friendly amendment, that we defer this or allow ORS that additional time for scrutiny?
I don't know if I would necessarily say an amendment. I would ask Commissioner Thomas to withdraw his motion, and see if there's any interest from the commission in allowing ORS to review the applicant's file in total, including the information that we receive, with any explanation that the applicant provides to ORS, and come to the commission and offer whether or not they still believe the applicant is fit, willing, and able.
Mr. Chairman,
Commissioner Thomas.
I would be willing to withdraw my motion and go in that direction. I think that we've all struggled with this, and that we all want the best and right decision. And I think that based on what you said about your personal knowledge of what happened in another case, I mean, there could be that there's some mistakes here. And as you said, also, we're not the entity that is supposed to investigate. So I would be fine with allowing ORS to go back in and get back with us on this.
Okay? And I would say I don't want to give anyone any false hope. ORS could come back and say, hey, you know what? Thank you for asking for that information that we didn't ask for. Now that we've received it, we have a different opinion. That could very well happen. But at the same time, we just need to make sure, in my opinion, in my humble opinion, we need to make sure we are as consistent as possible so that every party that appears before the commission can feel as if that our decisions are consistent and they're not being singled out or they're being treated any differently than any other applicant.
Mr. Chairman,
Vice Chair Belzer.
let me just, and this is quite unusual, but what if we were to reopen the proceeding, allow ORS to comment, but also allow the applicant the opportunity to come in and explain? He may dispute some of the, as you said, he may dispute some of the items on his record, but at least, I mean, if we're going to allow ORS to comment, it just seems fair that we might allow the applicant to be able to explain or give further information as well.
I think that's very fair. And so my knowledge of the rules of parliamentary procedure or Robert's Rule of Order being tested now because
I'll make the motion.
we had a motion.
I think it's been withdrawn, has it
Been
not?
withdrawn. And, okay, so now we're back at square one.
Yes, sir.
Okay, is there a motion?
Mr. Chairman, I would move that we reopen the record, set this matter for another virtual hearing continuation of the hearing to allow the applicant to provide further information on these late filed exhibits and ORS if ORS chooses to do so.
Hearing Vice Chair Belzer's motion, is there any discussion?
Mr. Chairman,
Commissioner Powers.
I think, and you mentioned it somewhere in one of your comments, that you don't want to give anybody false hope, because if the facts are the facts, I don't think it's going to change the outcome that the commission was originally looking at. So I don't know that needs to be part of the motion, but I think it certainly needs to be part of the applicant's understanding.
Commissioner Powers, I'm so very grateful for your comments because I totally agree. There's no two ways about it. What was submitted is concerning. It's concerning. It's concerning when it was submitted. It's concerning today. But it seems as if there's some gaps in the process that we need to fill in. And I think Vice Chair Belzer's motion will definitely be that gap filler so that when we do reach our decision, whatever that may be, it will be sound and it will be firm without any doubt about what happened with this process with this particular applicant. But to your point, whatever we decide to do here really has no indication on what's going to happen in the future.
I just hope or want it clear that in reopening this matter, it's limited to just that issue or these issues discussed and not a complete retrial of any sort.
I think that's your motion, right, Vice Chair Belzer?
To the extent that needs to be clarified, I mean, it is for the limited purpose of allow the applicant the opportunity to comment on these two late filed exhibits, the driving record and the criminal record, and as well as ORS if they choose to do so.
Thank you.
Thank you for the friendly amendment.
Chairman Williams,
Commissioner Caston.
I think anyone that may be looking in and not knowing really what's going on would think, goodness gracious alive, what is this? But I'll tell you, and I mean this honestly and humbly, I'm very honored to be a part of this group and the comments you made and the process that just occurred to get us to what we're getting ready to vote on, because everyone has that, I guess, that compassion, that heart that we don't want to do this wrong. We don't want to hurt people. We're trying to do the right thing. And sometimes that's not crystal clear. We can only make decisions based on the information we have. So I appreciate this whole process that we just went through to get to where we are. I just wanted to say that.
Commissioner Caston, I appreciate your comments. I will tell you before, I was fortunate enough to be a part of this commission. There was an allegation that the commission uses a lot of rubber stamps. So when I became chairman, the first order of business was to throw away all of the rubber stamps. And so whether it's up or down, my goal is to make sure that the commission is very thoughtful in the decisions that we make and that we are consistent. And all of that is in an effort to rebuild the public trust in the Public Service Commission of South Carolina. And I think this process, no matter how it may turn out, I think we are ensuring that the process here is fair. So thank you for your comments.
Mr. Chairman,
Commissioner Urban.
let me say that I have no objection to reopening the hearing and giving this young man an opportunity to come in with the assistance of his attorney and clarify some of the concerns that we have. And I hope he will understand that this is for everyone's best interest. We all have to follow rules and regulations, and if we fall short at times, there are consequences. So I don't think he's a bad person. That's never what I thought. I thought he was a nice young man trying to better himself, and I'm all for that. But before he operates a box truck and moving people's valuable possessions on our highways, I think we do have a duty to know, number one, why so many at-fault accidents in such a short time? Number two, did he have insurance at the time to cover the damages, if any, that were incurred? And these are concerns that I have because, ORS is the investigatory body, but we're the regulators. We ultimately have to decide these very difficult issues. And so I'm grateful we'll have a chance to look at it again. I hope that the applicant's attorney can clarify some of these issues for us and make our job easier. Because, we're the last line of defense for the public when it comes to protecting them and their property. And we have to be mindful. It's a balancing act. I want to be fair, but I also want to do our duty to protect the public interest. And that's my thought, and I look forward to hearing further testimony and evidence in this case. Thank you.
Commissioner Irvin, you're welcome, and I totally agree with you. And I think it's important to note that this matter, as the motion, as I understand the motion, this matter will not be decided until that next hearing sometime thereafter. And so this, for the public interest, this applicant is not operating in the community at this point. So it's still up for determination. Just so everyone out there watching understands that. Any more commissioner comments or discussion? Hearing none, we'll move to a vote on Vice Chair Belzer's motion to reopen the matter for the limited purpose of reviewing the late filed exhibits and hearing from the applicant and ORS on those said exhibits. Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Thank you, Mr. Chairman, members of the commission. Item 7 on the motor carrier agendas is docket number 2020-204T. This is the application of Rudy Roo's Moving Crew LLC for Class E Household Goods Certificate of Public Convenience and Necessity. And also, the applicant is requesting that the commission approve the binding estimate.
Is there a motion?
Mr. Chairman,
Commissioner Powers.
thank you. I move that the commission approve the application of Rudy Roo's Moving Crew LLC for a Class E Household Goods Certificate of Public Convenience and Necessity. I would further move that the commission deny the request for approval of rider number 1, the binding estimate at this time. I believe this binding estimate concept is a new concept for us, and it has not been previously approved by the commission. I further believe that the concept needs further study prior to implementation for any carrier. Mr. Chairman, I would point out that this issue may be the appropriate subject for a generic proceeding at a later time. I would so move.
Thank you, Commissioner Powers. Hearing Commissioner Powers' motion, is there any discussion? Hearing none, we'll move to a vote. Starting with Vice Chair Belzer,
I vote aye.
Commissioner Caston,
Aye.
Commissioner Urban,
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers,
Aye.
and Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, the staff would propose taking items 8 through 11 together. Item number 8 is docket number 2020-241-T. Jeanette Kinlow, DBA A&J Quality Transportation, requests an extension of time until April 22nd, 2021 to comply with commission rules and regulations. Item number 9 is docket number 2020-235T. Angel Hearts Company, LLC, requests an extension of time until March 31st, 2021 to comply with commission rules and regulations. Item number 10, 4T's Transportation and Tours, LLC, requests an extension of time until May 4th, 2021 to comply with commission rules and regulations. And item 11 is the application of J&L's Medical Transport under docket number 2020-237-T. J&L's Medical Transport LLC requests an extension of time until May 31st, 2021 to comply with commission rules and regulations.
Is there a motion?
Chairman Williams, this is Commissioner Caston. I'd like to make a motion.
The floor is yours, sir.
I move that the request for extension to comply with commission rules and regulations in items 8 through 11, as described by Mr. Butler, be granted.
Thank you, Commissioner Caston. Hearing Commissioner Caston's motion, is there any discussion? Hearing none. Vice Chair Belzer,
I vote aye.
Commissioner Caston,
Aye.
Commissioner Urban,
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers,
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, item number 12 is also a request for an extension of time, but it's a little bit different from the 4 that we were just discussing. This is docket number 2020-251T, and this is a request of Rapid Medical Transport, LLC, for an extension of time, and they gave the commission alternatives. They said they'd like an extension until May 5th, 2021, but they'd really like an extension till August 4th, 2021 to comply with commission rules and regulations. As I understand it, Mr. Chairman, this original order in this case granting authority was dated November 9th, 2020. So either one of these dates could be appropriate for an extension. It's up to the commission and the commission discretion.
Thank you, Attorney Butler. Is there a motion?
Chair Williams, this is Commissioner Caston. I'd like to make a motion.
Commissioner Caston, the floor is yours.
I move that the commission grant the request of Rapid Medical Transport LLC for an extension of time until August 4th, 2021 to comply with commission rules and regulations.
Hearing Commissioner Caston's motion, is there any discussion? Hearing none, we'll move to a vote, starting with Vice Chair Belzer.
I vote aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, beg your discretion one moment, please, sir.
Absolutely.
Give it to me.
Thank you, Mr. Chairman. Thank you for that brief break. The only remaining item is under the Kiowa Island Community Association. We have two dockets, docket number 2020-37T. Commission's previously approved a Class C charter certificate today. In addition, though, up for vote is a request for exemption regarding the regulation 103.153.1 regarding a vehicle ID marking.
Mr. Chairman, I have a motion.
Vice Chair Belzer, the floor is yours, ma'am.
Mr. Chairman, I move that the commission grant the exemption requested by the applicant from Commission Regulation 103-153.1 vehicle ID markings requirement for the two vehicles listed by the applicant, a Toyota Sequoia and a Mercedes vehicle as well. The applicant states that its customers are solely members of the applicant's private club, and the vehicle is not available for charter by non-members. Since the vehicle may not be chartered by any non-member, no signage is necessary, and waiving the regulation is not adverse to the public interest in this particular instance. Therefore, I move that a waiver of Regulation 103.153.1 is appropriate, and so move.
Hearing Vice Chair Belzer's motion, is there any discussion? Hearing none, we'll move to a vote, starting with Vice Chair Belzer.
I vote aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
And Mr. Chairman and other members of the commission, that does complete the commission's transportation agenda for today.
All right, thank you, Attorney Butler. Ladies and gentlemen, we will have our next business meeting February 24th at 11 a.m. See you then.